Good afternoon, everyone. Thank you for participating today. My name is Jason Hanford. I'm a partner at the Chartwell Law offices. I practice specifically in Pennsylvania workers' compensation. I represent employers and insurance carriers in Pennsylvania, primarily in workers' compensation matters. So today we are discussing what will be the fifth in our six-part series of Pennsylvania workers' compensation 101 topics. We're trying to take a 50,000-foot viewpoint of how the Pennsylvania Workers' Compensation Act applies, and give as much granular detail as we can while still explaining the basics. So far in this course, we've talked about workers' compensation bureau forms. That was the boring one that put everyone to sleep. We talked about course and scope of employment. We talked about claim petitions, filing them and defending them. The last seminar we had, which was about 2 months ago, we talked about wage loss exposure, how to try to get out of wage loss exposure once you have an accepted claim. We are here today talking about mitigating medical exposure, the other amounts of money that are paid for Pennsylvania comp claims. How do you get out of the medical exposure? And in our wrap up for the 101 series in 2 months, we will be talking about settlements. So if you've been with us throughout, and I know I see a lot of names, I know a lot of you have been with us from the beginning, welcome back. God bless you. I appreciate it. If this is your first one and you want to go back and see some of the other seminars, they're all available on our YouTube channel. They're available on the website. You can get caught up. You can use them as instructional videos, or you can use them to put yourself to sleep at night. So a few ground rules, explanations. A couple of times we'd had the question of, can I see you? So you're sitting there slurping your soup, having your lunch. Can we see you? Can we see you out there on your Zoom? We cannot. This is the only thing we can see is each other. So we don't have a video of you as the participant. So you can do whatever you want on your end. The problem with that is you can't hop in and ask a question, and I can't see what you're asking. So if you do have any questions, what we need you to do is you go to the bottom of your Zoom screen, and there should be a section called Q&A. That stands for question and answer. You click on that. You put your question in there. I will be monitoring that throughout the presentation, and I'll try to get to those questions as quickly as I can. If I don't get to a question, I'll try to get to it at the end. And if we can't get to all the questions, your name is there and we can follow up with you. Or you can always email us if you have a question that you don't really want to put out in front of the entire forum. So we're readily available. Along those lines, when you're asking questions, when we're answering questions, disclaimer that we're not providing any specific legal advice today. If you have legal questions and you want legal representation, that's what Chartwell does. But don't go make any bad decisions today based on what you saw in the seminar. We're not providing specific legal advice that applies specifically to your claims because, as you know, every question is claim specific. So all that fun ground rules out of the way, I want to introduce my co-presenters today. We have from our Harrisburg office, Mr. John Spadea. John, you want to say hi to everybody?
Good afternoon, everyone. Thank you for allowing us this opportunity. I look forward to getting into some of these issues.
Very good. And Barack Casuto from our Valley Forge office. Say hi, Barack.
Hey, everybody.
So Barack and John are longtime workers' compensation practitioners like myself. They are very, very skilled and trained in dealing with medical exposures. And in particular, they're two of the foremost experts in fee reviews in Pennsylvania. And if you really want to liven up a cocktail party, you'll go there and you'll brag about your fee review expertise. But it's a very niche area, but these are the guys to talk to about that sort of thing. So I'm glad you guys are here today. I think it'll be a good discussion. I want to set the table, so to speak, as we get into the substantive presentation. What are we talking about today? We're talking about medical exposure. The last time we did one of these, we talked about wage loss exposure. Setting aside some peculiarities, that's really what you're talking about when you're dealing with an accepted or adjudicated Pennsylvania workers' compensation claim. You have the wage loss aspect and you have the medical exposure aspect. I think pretty much everybody on this presentation, anybody dealing with Pennsylvania claims today, knows that over the last at least 15 years, probably longer, medical exposures in Pennsylvania have been skyrocketing. A wage loss exposure, it's limited. It's going to be limited by the earnings of the employee. And if they're a high earner, it's going to be limited by the statewide average weekly wage, the cap. So you're going to know what your wage loss exposure is. You're going to know if it's a big wage loss case or a smaller wage loss case, essentially from the outset. When it comes to medical exposure, it's a little bit more unknown. You could have an employee who's making $200 a week, $300 a week, and the medical exposure could be $50,000 to $60,000 a year, depending on what treatment they're getting. So I think it's as important in every single claim as wage loss, and I think in most claims it's probably more important. So we're going to start at the beginning. It's a bit of a refresher, but I want to lay a proper groundwork. I'm going to start with you, John. Can you tell us what happens in the initial 90 days when a claimant first starts treating after there's an accepted work injury?
Yeah, so thanks, Jason. For some of you, this is going to be pretty basic, but obviously the first 90 days, it's one of the few arrows in our sling from a defense perspective that we have to control medical treatment through the use of a panel. And just some basic facts, I'm sure most of you know, but if you don't, you need a panel in Pennsylvania. You need to provide that panel list of providers to the claimant. And it's where the claimant is required to treat for the first 90 days. And if they don't treat with that panel, if they go quote unquote off panel, you as the insurer or the employer are not obligated to pay for that medical treatment. Again, I would assume that most everyone here has and uses panels. You're probably well aware that you need at least 6 providers. At least 3 of those need to be physicians, no more than 4 coordinated care organizations. But I did want to start here because I think it is one of the underappreciated and most important tools you have to try and control costs. In my experience, I'll just be honest, maybe Barack and Jason have a different perspective, but we don't typically see much litigation over panel treatments once it gets to the judge level. Either the claimant is already outside of that 90 days, or maybe not all of the paperwork is in order. And if you want more discussion on that, I recommend you go back to, I believe, the first presentation on the proper forms and what you need to do to get the panel. But what I've found, at least for you as an adjuster looking at the claim or working the claim, it can be one of the best tools, that being a panel, to prevent it getting into the litigation stage. I think it's vitally important that you review your panel, vet your panel, work with the employer on picking the doctors. I know it can be overlooked and it's easy to just kind of go with whatever urgent care center is down the road or close or convenient. But this really is the difference, getting a good medical opinion that you trust, that you can work with, providers that are responsive, that can really take a case that doesn't need to get into litigation and keep it out. I don't know, Barack or Jason, if you see much litigation otherwise, but I think without getting into the too nitty gritty, that's just the one point I want to hammer, is the importance of getting a good panel, getting doctors that you know, that you trust, and that frankly are responsive and easy to deal with. I don't know. Again, I don't know how much actual litigation we typically see. It does come up from time to time, but by that point, we're pretty much past the 90 days.
Yeah, no, I agree. I don't think you're going to spend a lot of time litigating over treatment, whether it was within the panel or outside the panel. You might, quote unquote, get a win once in a while where you get to deny a bill because it was with a provider that was strictly outside the panel. The claimant wasn't referred to that provider by anyone that was on the panel. That's going to be few and far between. That's not going to win or lose the case for you. I agree with John that you can lose your claim or create a pretty big medical exposure if you have a bad panel of doctors. So definitely, keep your eye on that. And the other thing is you need to be aware of if your claimant is treating within the panel, and sometimes claimants will continue to treat with the panel doctor after the 90 days or with the referred specialist. Sometimes you're not going to like what that doctor says. You're not going to like what the opinion of the panel doctor and or the specialist that they referred them to. You don't have to be beholden to their opinions after 90 days, but you need to be aware that if you're litigating something and the ortho who the panel doctor sent the claimant to is saying, claimant needs this surgery and the surgery is work related, and your IME that you got separately says claimant's fully recovered, there's not a darn thing wrong with him or her. The judges sometimes, at least in my experience, John, you can tell us if it's like that in the rest of the state, the judges will put some weight on that doctor who was, independently the claimant was sent there by your own panel doctor. Is that your experience on your side of the state, John?
Oh yeah, no doubt. And you will always hear claimant's attorney refer to the panel as, oh, that's the employer's doctor. Even the employer's doctor is saying A, B, C, and D. I always object and or cringe when they say that. These are obviously independent opinions, but it is something you have to be aware of when dealing with panel opinions. Frankly, in my experience, I tend to appreciate when a panel doctor will call it as they see it, so to speak. I think it's similar to IME doctors. The judges start to learn the names pretty quickly, especially if every single injury is a sprain and strain. So, I mean, that's one of the things I frankly would recommend on my cases and my clients. Like, look, maybe you don't always get the opinion you want, but I think that will end up lending credibility on the cases where you actually, and it's similar to IME doctors in that respect.
Yeah, I agree. So let's assume and hope that we've properly set up a good panel with good treaters. You're going to get medical bills. You'll get medical bills from the panel doctors, and if the claimant starts treating outside the panel, or they go somewhere else after the 90 days, you'll get those medical bills too. So Barack, let's get into the meat of the presentation. What medical bills do I have to pay for when they start rolling in?
Sure. So the Act requires defendants to pay for reasonable, necessary, and causally related medical bills. So in terms of mitigating medical exposure, the first thing is to just cut out anything that's not covered by the Act, rather than we'll cover later, disputing the amounts of individual bills. So the first question is, what constitutes medical treatment, right? The Act provides coverage for goods and services and even travel expenses related to healthcare from licensed providers in Pennsylvania. So you're looking at, doctors, chiropractors, pharmacies, all the stuff you would expect. Some forms of alternative medicine are not covered. So, ayurvedic therapy or crystal healing, that sort of stuff is not considered medical care, even if the claimant may consider it, for their own purposes. So those bills can just be denied as not constituting medical care under the Act. The other piece is goods, durable medical equipment, which can also, in the past by the courts, has been found to include vehicles. If a claimant is disabled and requires some, special modified transport, or even home modifications if the disability is particularly limiting. Those have been classified as orthopedic appliances, and the Act mandates coverage of those in certain instances as well. The other piece of it is reasonableness and necessity. Obviously treatment that's not reasonable and necessary is not covered by the Act, but how do we determine what is reasonable and necessary? Well, the Act provides a method for defendants to request utilization review, which is the process to determine reasonableness and necessity. And you can, upon receiving a bill, submit a utilization review request, which goes to the Bureau, who then assigns it to what's known as a URO, or Utilization Review Organization, who in turn will then assign it to a reviewing physician. The Act requires that the reviewing physician be of the same specialty as the physician who's under review, and you'll get an opinion regarding reasonableness and necessity there for the treatment that you ask about. There's a very helpful provision with regards to the utilization review laws for defendants, which is that the law provides an automatic supersedious for all treatment which is subject to utilization review. So the simple process of asking for this utilization review means that while that review is pending, any bills can be denied as you are pending. And if you're attempting some of the other cost control strategies that we're going to talk about a little later, this can be a very good preliminary step to sort of gather the wagons and assess other strategies. It can also be a way to win in its own right. The challenge you'll run into here oftentimes is that one piece of it is that utilization reviewers cannot consider cost. And I know that's a lot of you are on here today. How do we limit costs? Unfortunately, that is not something they can consider. Another limiting factor to utilization review is that the provider, as I mentioned before, has to be the same specialty as the provider under review. Some specialties are more lenient regarding what constitutes reasonable and necessary medical care. And you're going to have have another physician of the same specialty making that determination. There's another small provision I wanted to cover regarding reasonableness and necessity, which is not frequently used, which is called peer review. And that is after you get a utilization review determination and you're in front of a judge, you can request peer review. And it's not often used, but there is a nice provision, there is a nice aspect of the law which allows the judge to assign another doctor to review and weigh in on these issues. And the nice piece about it is that the cost is not assigned to the defendant. The cost is actually assigned to the bureau. It's discretionary, the judge has to grant it. But in cases where you're litigating the reasonableness and necessity and the litigation costs may start eclipsing the cost of the treatment at issue, it's another tactic you can consider. You cannot, however, deny treatment as unreasonable and unnecessary sort of on your own. You do need to utilize these processes if you want to challenge these aspects of treatment. One other thing I just wanted to touch on very briefly is causally related. And I know John's going to cover that in more detail, but I wanted to touch on it in the context of utilization review because there's been some recent case law that has said that defendants are actually required to file utilization review to challenge causal relation of a medical bill. A lot of providers haven't caught on to this yet, and they're not actually litigating it in the proper context, but some have. And they're arguing that because the defendant did not file a utilization review regarding lack of causal relation, which would be like, an example would be you get a bill for pain cream for the claimant's knee when he has a back injury. You could say that's not causally related. There's case law saying that you have to file a utilization review in those instances. And the providers have started arguing in some instances where if you don't raise that argument in utilization review, it's waived. But I will let John cover more of that in the causally related subject matter.
Yeah, let me
thanks,
just jump.
Barack.
Can I just jump in for a second, guys? I just had a couple questions, and we have an audience question. So anybody else has any questions for the Q&A section? That's awesome. Make sure you put them in there. And Barack, the question is about massage therapy. I think it's a general question about whether massage therapy can be a compensable treatment for a Pennsylvania workers' comp injury. I'd like you to answer that, but then I want to use that as an example just very quickly to walk people through as to how this actually works in Pennsylvania. So question number one, massage therapy. Is there a scenario in which massage therapy is compensable and is a compensable treatment?
Yeah, so I think the questioner may be asking because I believe there was some case law previously where it was found not covered. And I believe it was because at the time, there was not a law providing certification for that healthcare provider. That has subsequently changed. There is now state law providing certification for that. So it is compensable. It does need to be provided under the auspices of a provider who is licensed to provide that treatment. So it can't be just anyone. It has to be a certified, licensed massage therapist.
Okay, so let's say we're getting those bills in and claimant Bob is going to massage therapy every single day of the week. And the adjuster's getting these bills and they see the bills and they say, my goodness, that seems a little bit unnecessary. It seems maybe unreasonable. Maybe this is something I need to consider utilization review for. What is their first step, or if they contact counsel, what is your first step, Barack, if you're considering UR of a treatment? What do you have to do procedurally?
Sure. Well, if it is something that you really want to, take to the mat, so to speak, you may want to go out and get an IME as sort of a backup procedure, because ultimately you don't control what the utilization review determination is going to say or where it's going to be assigned. So you could get an adverse determination. And if you really want to go the distance on it, it helps to have an IME in your back pocket. So you'll find a physician, an expert who you believe will give you a fair opinion on the reasonableness and necessity of the treatment at issue, and you have that as a backup. So that's something you may want to get started. Secondarily to that, you're going to request a utilization review of the treatment at issue, and that'll give you an automatic supersedious, as I mentioned earlier.
So you filed the UR request on WICAS. We did not do a 101 section on WICAS, and I don't want to. So if you need anything on that, just reach out to us. But you filed your UR request on WICAS. It's assigned to a utilization review organization by the Bureau. We don't pick those. The carrier doesn't pick those. The adjuster doesn't pick those. The Bureau picks which URO it goes to. They've reviewed the treatment and issued their utilization review determination, in which they determine whether the treatment essentially has to be paid for. If you don't like what they say, Barack, what's the next step?
So you get a bad UR determination. That's why we went out and we got that IME if we wanted to go the distance on this thing, because now we have another medical opinion saying this treatment is not reasonable and necessary, and we can file a petition to review the utilization review determination. That's assigned to a workers' compensation judge, and we will schedule the deposition of the IME physician and move forward with litigating that issue. I will say, though, in those instances, you do lose the supersedious if you get an adverse determination. So you do have to start paying those bills again. However, if you're ultimately successful, if the judge reverses the UR determination, you can get that money back from the supersedious reimbursement fund.
And if you lose before the workers' compensation judge, it's the usual route of appeal through the appeal board and then theoretically to the Commonwealth Court.
Yeah.
Which is something I think we'll distinguish later when we talk about fee reviews. Another thing that our clients should be aware of, I believe, is when you, and Brock mentioned it, once you file the utilization review request, you get that stay of payment. And if it's the massage therapy that was asked about, you get a stay of payment for every single massage therapy bill you get until the utilization review determination is issued. Contrast with what we'll talk about in fee review, which, Brock, I think you'll agree is bill specific. If you're fighting in fee review, you're fighting over a specific date of treatment, and it might not give you the long-term relief that you would get from a utilization review determination. We have another question. I don't think our guests can see who's asking the question. This is a seasoned and well-respected workers' compensation expert who's asking us a question. She wants to know, is it possible to word a utilization review request to ask if a brand prescription is reasonable and necessary in comparison to an available generic? So can we use the utilization review process to push towards a generic prescription, Barack, as opposed to what we might think is an overpriced, specifically prescribed prescription?
My recollection is that utilization reviewers can consider alternative treatments in making their determination. There is a box in the form when you file a utilization review request where you can input the treatment under review, and I don't see why you couldn't phrase it in such a way as to posture the case that in that respect. However, I would note that one of the things the regulations say that reviewers cannot consider specifically is cost. So it would be a lift to say that the generic is more reasonable and necessary than the brand name if the only differentiating factor is cost.
Yeah, I think it brings up two things. I think you're exactly right. You can word your utilization request specifically to ask the URO to address something. That doesn't mean that they will. It doesn't mean that they'll even necessarily read through that section of your request, but it's something to be aware of, in my opinion, even outside of this issue of generic versus brand name. Whenever you're filing a utilization review request, I think you want to be as specific as possible as to the provider that you're asking to be reviewed, what treatment you're asking to be reviewed, and that it's on an ongoing basis. Because you can't rely on that UR doctor to go through all the medical records and suss out treatment that you perhaps didn't identify in your request. So when you're doing those requests, be mindful of everything that you want the URO to cover. Anything else we want to touch on before we move out of specifically utilization reviews, Brock or John?
I think the only thing I would add, UR, as has been noted, gives you that supersedious, but again, it is provider specific. I think most people will see a claimant is treating, getting prescriptions from one doctor, and you are them, get a stay, or even you get a favorable UR decision, and they just turn around and go find another doctor doing the exact same medication. I would just caution anyone, you cannot use a favorable UR from one doctor to deny, even if it's the exact same treatment, same med from a different doctor. That can get you into trouble. I don't like that interpretation. I don't like how it is, but it's what the law is, and you just got to be careful there, or you invite a penalty.
Yeah, I agree. That's a good point. John, when Barack first explained to us what medical treatment Pennsylvania insurers and employers have to pay for, he said it has to be reasonable and necessary and causally related. What are we talking about in Pennsylvania when we're talking about causally related medical treatment?
So I am, after doing this defense work for a number of years, somewhat of a cold-hearted cynic. So the best way I'll describe it, treatment is causally related whenever a doctor says it is and the judge believes them. In general, it's a common, most times it's a common sense analysis. Is this treatment being prescribed to address the work injury? Oftentimes, the most litigation we see is over this issue. And to be clear, you are not liable to pay for treatment that is not related to the work injury. It sounds simple, but again, we see, I think most of at least the litigation I see on medical bills is over this key issue. Because you don't have to pay for the medical treatment if it's unrelated, just be aware that you will risk penalties. And frankly, you will almost always get a penalty if you start denying treatment on that basis. If you win and the judge says it's unrelated, then there's no penalty. You don't have to pay for the treatment. If you lose, though, it's kind of all or nothing. You have to pay for that treatment and potentially the penalties as well. I'm going to go through some scenarios kind of where we see it, where I think most of the adjusters and insurers and employers, frankly, face some of these questions specifically. But there are times you can be proactive if you think a treatment's unrelated, or you think the claimant is starting to, as Jason, you noted, he has a back injury, but now he's trying to add treatment for the knee. And I would just add, you see this more often than not. They will always say there's referred pain or related pain going down to the knee. It does happen a lot. And you can be proactive and file a review petition on your own to put that issue right before the judge. This would avoid a penalty per se, because again, you're being proactive. However, if you're not paying it, you can still get that penalty. You could also file another petition to address the description of injury. Again, if you just have an accepted low back injury and now he's treating for the knee, you could again file a petition to address that. I don't typically recommend that because you would need typically some kind of IME or medical opinion to support it. Otherwise, because workers' compensation is so unkind to the defendants, you have to have a reasonable basis to file. And frankly, I would recommend that in those situations, let the claimant file and fight it that way. But so, okay, how does this come up? When do we see this? I was, ironically enough, just litigating a hearing this morning on a similar issue. You've got a claimant that is receiving medications, and you're paying out the wazoo for medications A, B, C, and D. And all of a sudden, the doctor is switching medications and adding medications that may be for example, a tremor. The doctor even says tremor on his note, but the injury has nothing to do with tremors. In those situations, I would say on its face, it's not related. Of course, you will get into litigation and they will always say, oh, well, my injury is causing my tremors, et cetera, et cetera. But that's typically a common situation. When it comes to these medical bills issues, not necessarily causally related, but some of the other common scenarios you run into, I would advise you be aware of the billing on the proper forms. You are not liable to pay for medical treatment unless it is properly billed under the Act. Again, there was a very nice presentation on proper forms, but in short, it needs to be on the HCFA, the medical treatment form, I believe, off the top of my head, the L100. I'm sure Barack can correct me on that. But there's forms prescribed the provider needs to use, and they need to present medical documentation to support the bill. I see this all the time on cases when we get right to the end of settlement, and they all, claimants always want all their bills paid, and they hand you these ledgers or one-page statements from hospitals or providers saying you owe $20,000, and that's it. Or even it itemizes the treatment on the ledger. That's not enough. Under the Act, you need to present on the proper HCFA forms with supporting medical documentation. To that end, if you're settling cases, I see this as well, or even, if you have a case where you've won and it's been terminated. If those bills have been previously submitted, try and track those down. Oftentimes, claimants' attorneys, if they know they're going to get paid, will help you and reach out to the providers to get the bills resubmitted. I don't know if Jason and Barack do this, but I always, if I can, like to put that onus on the claimant when we settle, say, hey, we'll pay for medical bills upon proper resubmission. And I put that right in the settlements themselves. That way, otherwise you can just be inviting a penalty. And frankly, I always take the approach that if you want this bill treated, you make sure it gets submitted properly. We're not going back through 18 months or sometimes 10 years of medical bills, treatments, emails, and submissions to get the bills you want paid. That's just my own personal experience. I can let Barack and Jason correct me if they like a different approach, but it's just something to remember with bills and forms. Another big issue, kind of just to broach the topic, is pre-authorization. I know most of you probably know, and if you don't, pre-authorization is not required in Pennsylvania. You will get a call from a surgical center or hospital saying, hey, we want to do surgery on this low back sprain. Can you authorize it and guarantee you'll pay? You are not required to do that as an insurer, a defendant, or employer. And I bring this up because there is a case out there, if I can, the McLaughlin case, where it seems to suggest the opposite. And in that case, there was a penalty filed because if you read the case, they will say the adjuster did not pre-approve a surgery. However, and I bring this up because claimants' attorneys will bring this up. There are some law firms on the borders of the state that will love to bring this up and threaten penalties and scream and yell and call you all sorts of names. But if you read that case closely, it involved a termination petition where they were litigating whether or not the claimant had fully recovered. And in that case, provider said, hey, will you authorize this surgery? And the adjuster in that case wrote back and said, we're not paying for any treatment at all because we are litigating this. We believe the claimant's fully recovered. The court basically said that's bad. You can't do that. So that McLaughlin case, I do not believe stands for the proposition that you have to pre-authorize treatment. Rather, you cannot unilaterally stop paying for medical bills, even if you have a full recovery opinion. And I know most of you know that, but I give you that interpretation because we do hear that from time to time argued from claimants' firms. All right, just a couple other issues, and I'm just going to roll through these, not to bore you all to death, but sometimes you can see an apportionment issue. I've had this come up a couple of times on cases where, look, your injury is at the L4-5 level, and you've never accepted the L5-S1 level, and the claimant's getting treatment to both. Or you have a chiropractor. You have an accepted low back injury, and lo and behold, the chiropractor is giving therapy to the shoulders, the arms, the legs, and everything under the sun. There is a case out there that says you cannot apportion treatment, and it would seem to suggest that you have to pay for all the treatment that is not even related. In that case, if you read it again closely, I recommend you do. It's the Huddy case. Basically, what the judge did is he said, you only have to pay 50% of this bill. You pay half for the treatment that's unrelated, and you pay for the treatment that's related. You don't have to pay for the other half. So the takeaway there is you cannot do a 50-50 or percentage. The courts don't like that. But I would still suggest you do not have to pay for unrelated treatment. I have had cases where a judge has specifically ruled this level of the spine is related, this level is not. Provider, you have to go back and rebill the related treatment. I've dealt with that with chiropractors. It usually ends in litigation, but again, I think that once providers know and the claimants know that they're going to get some payment, help us out and bill, you see them cooperate, at least to that extent. I don't know if Jason and Barack have a different experience.
No, I think you state it succinctly, and I think your examples. I think for me, the through line from all your examples and what I try to tell my clients is, if you have an accepted or adjudicated injury and you want to deny a medical bill, don't be shy. Don't be shy in denying medical bills. It's always good to be aggressive in claims handling, but do it with intent. and know why you're doing it. And I think the explanation with regard to pre-authorization was exactly that. And where they got in trouble in that McLaughlin case that John referenced was they had all the authority in the world to say, no, we're not going to pre-authorize, but they got sloppy and said, we're not going to pay for anything. And you want to have, to the extent that you can, a reason why you're denying that bill. Because when John or Brock or myself get in front of the judge and the judge says, why didn't your client pay for this? We just need to tell them why. And it can't be something that we made up after the fact, because unfortunately, sometimes the adjuster will have to testify. And we don't want to put any of you in a tough spot where you're trying to explain why you did something when it might not have been the initial reason why you actually did that. So I think with any of medical treatment, whether it's prescriptions, surgeries, anything like that, take a breather, take a beat, talk to somebody else, that talk to your attorney, talk to another adjuster or supervisor. And, even if it seems like it's some minor bill, just have a reasoning behind it, document your file, put it in your log notes. And if you do that, I can promise you 99% of the time, you're not going to have to worry about penalties or anything of that nature. John, it was touched on by Barack, and I know we don't want to spend too long on it. In the day before the dawn of coronavirus, the Commonwealth Court of Pennsylvania issued a decision addressing causally related medical bills in Pennsylvania. And as Barack explained, they essentially said that if you dispute whether treatment is causally related to a work injury, your venue of fighting that is within the utilization review context, and you shouldn't just write not causally related on your denial. I don't believe, Brock, was that appealed to the Supreme Court? Do you know if there was any further decision on that?
I don't think it was appealed.
So as we sit here today, now 2 years later, this Commonwealth Court decision is hanging out there. And we've written articles about it that were, readable. And we try to alert people. And every time I get a bill that somebody emails me about that says it might be causally related, might be an issue, I tell them about this case. And you guys can give your input. My explanation is this case is out there. In my opinion, it's the controlling law. I don't think all the judges know about it. More importantly, I don't think all the providers know about it. So you could deny this bill that's for foot cream when you have a concussion injury and say, yeah, well, duh, it's not causally related, and nothing will ever happen. But by the letter of the law per that decision, if you deny the foot cream that's issued for a concussion, you could also be in a penalty situation. What's going on in the central part of the state in your cases you're handling, John?
So I 100% agree with both Barack and you, Jason. And I just want to, it is starting to come up, starting to percolate, starting to trickle down. And I want to add a little context. So the case that we're referencing came up in the fee review arena. And as we noted at the start, I don't want to get into the nitty gritty and bore you all to death. If there's an appetite, we're happy to do a more detailed dive into fee review and explain kind of how it's crazy and why. But there was a dispute over this bill, and it was a medical only claim. And I believe it was a compound claim of some sort, but in any event, it was basically the prescription was submitted and nothing else. And the insurer, as anyone would, denied it and said, it's not related. We don't have any treatment. It doesn't even reference the injury. And the court in that case and a couple cases after have done a lot of gymnastics and created what I believe are some crazy results. So Jason is right. You per the letter of that case, if you want to challenge causal relation of a bill and avoid payment, it suggests you need to first file utilization. That is crazy because the statute regarding utilization review specifically says it is not to address causal relationship. The court in its decision basically said, well, it's subsumed or it's part of the process. So that's what it says. Here's where I'm seeing it personally. The providers that know about this, I've mostly found to be pharmacies and chiropractors, and they're starting to communicate a lot with claimants' attorneys. And I have had at least 2 cases now ready to settle day before the CNR, literally. All of a sudden, the provider is entering, an attorney for the providers entering their appearance and emailing me about all of these bills and threatening, fee review. And you get in this situation where you can have, before a workers' comp judge, an opinion, and I'm litigating one of these issues now, that said this treatment's not related because here's the injury. Well, you can have that potentially decision before the judge, but all of a sudden the provider files in fee review, this separate, distinct but related venue, and can still try and seek payment that way. I do think it's a mess because I think it's still unsettled on how the courts will take that. I believe personally, and this is just my own opinion, not necessarily shared by Jason Barak or Chartwell itself, but I don't think the court fully understood what they were doing when they rendered this decision. I don't think the judges are very well aware of it. I think if you try and take this argument about causal relation on a utilization review issue before a judge, you're going to run into some headwinds. And also just the practical implications of what the court is telling you to do. If you really do have to address causation through utilization review, you're going to have to get the UR, as Barak went through in great detail. That UR is not going to address causation. It's assumed at that point. You will then have to have a separate IME or records review or other opinion that you will now have to pay for in addition to the rest of the case to try and address this issue. And if you get a UR determination that says reasonable and necessary, you will almost then be forced to file your own petition challenging that determination on the basis of causation, just so it holds up in a fee review arena. I probably bored half of you to death. I'll get off my pedestal now, but I do think this is not to be too doom and gloom, this is an issue we're going to see a lot more, especially as the providers catch on. So again, if there's appetite, I'm happy to discuss further, and I welcome Barak and Jason's input.
Yeah, your passion about medical bills and causal relatedness is it's infectious. No, I think if anything, what we've learned, and we have to move on, but I think we've learned that what we talk about causally related, reasonable, necessary. We told you reasonable, necessary, you're probably going to have to go to UR. And now John's telling you that depending on what happens going forward, you might end up in UR for causally related as well. So the UR process is not going away. If there's a takeaway from our first half hour here, be familiar with it, know how it works. So we want to move on. One tool for dealing with medical exposure that I'm just going to touch on as quickly as possible is settlement. And, people don't like to settle because it involves me coming to you, my client, and saying, give me a bunch of money, and I'm going to go give it to that claimant who you may or may not think is a dirty liar, and they're going to have a happy life, and you have to explain to your boss why you just put 6 figures on a workers' comp claim that nobody really thinks happened. So settlement can be painful. It can be uncomfortable. It can feel like a loss, but it's also a tool. And there's lots of areas where you can settle your case, and paying $50,000 today might save you $250,000 in medical exposure over the next 10 years, or in cases that we've settled, Barak, over the next 6 months. So it's an arrow in the quiver. We're doing a whole presentation on settlements in 2 months from now, which is by my calendar, March. So we're going to talk about settlements and how they're used as tools to close out the claim, but be aware of it. One way to control medical treatment in Pennsylvania claims is to get out of the Pennsylvania claim. So I don't want to go any further on settlement because we have to talk, Barak, about fee reviews. Yes. So can you explain to everybody in about 5 to 10 minutes how the entire fee review process works in Pennsylvania?
Yeah, of course. So fee review is sort of a parallel forum for litigation in Pennsylvania that is related to the workers' compensation arena, but is not identical to it. So when we litigate these petitions, most of the time we're in front of workers' compensation judges or the appeal board. Fee review occurs in front of a fee review hearing officer. And the fee review hearing officer, those disputes are limited to disputes between the defendant, the insurer-employer, versus healthcare providers. The claimant and the claimant's attorney are not involved in these disputes. The subject of these disputes are supposed to be limited to timeliness of medical bills, whether they were paid on time, and the amount of medical bills. It's a pretty narrow issue, but it can get pretty complicated. I know a lot of our clients have whole units internally, or they have outside vendors they use for processing medical bills. So this can be a complicated subject matter. In terms of timeliness, the Determination is actually relatively simple. Defendants have 30 days when they get a medical bill to process it and issue payment, denial, or they can request utilization review, they can request more information. There's a lot of options when you get a medical bill, but the time you have to do that is in those 30 days following bill receipt. The other piece is the amount. We'll get to that in a moment. But on the subject of timeliness, I just wanted to touch on quickly, there's also a time limitation on when a fee review application can be filed. So quickly, defendants don't file fee review applications. Employers, insurers, we don't get to decide to go in front of a hearing officer. Fee review applications can only be filed by healthcare providers. So if a healthcare provider files a fee review application, there's a question of whether that fee review application is early or late. And a fee review application being late is one of the easiest ways to have some cost savings or get out of that form and the associated litigation costs. So the time limits for that are 30 days following notification of a disputed treatment. So you issue denial, you issue payment for a certain amount, or 90 days following the original billing date, whichever is later. So in some of these instances, if a bill has been paid in part, in whole, or denied, and then a provider's come out of the woodwork, years later, they may not be able to get into fee review at that point. So that's something that's helpful to be aware of. The other issue is, why is any of this important? We're talking about individual bills here. The issue is that judges, workers' compensation judges, will usually defer to fee review determinations on issues of timeliness and amount. And medical bills, as we covered at the very beginning of this session, can add up very quickly. So if you have a series of adverse fee review determinations, I think we mentioned briefly, no particular context, compounded pain creams earlier. Those creams can be $5,000, $6,000, $7,000 a tube. If those bills add up and you have a series of adverse fee review determinations and you're not paying them and you're not appealing them, that can lead to a penalty situation where there's a lot of money on the line, and the judges are going to be inclined to defer to those issues of amount and timeliness. In terms of what else is covered in fee review, we also have the issue of downcoding. So that is one of the options the defendant has to mitigate medical exposure, which is the subject of today's session, when they receive a bill. So downcoding is not well known and not often utilized. And what it is that if you get a bill for a medical procedure, a defendant can change the billing code on that bill and downcode it essentially if there is support in the Medicare guidelines to do so. And that can result in substantial savings. A primary example of where this was done for some of the workers' compensation professionals who are on this call who've been doing this for a number of years may recall VAX-D. Downcoding was used successfully in that context to limit medical costs across the state, essentially, where a particular compression therapy was being used and billed at outrageous rates. Defendants are successful in downcoding that, and that was ultimately upheld by the appellate courts. The challenge with downcoding is that it's a very procedurally intensive process, a relatively procedurally intensive process, in that when you receive the bill, the defendant is required to send out a notice letter to the provider saying to them, we are going to downcode your bill, and they give them an opportunity to discuss the downcoding. And then if a fee review application is filed, the burden of proof is on the defendant to show that it strictly complied with those procedural requirements. So, it requires sending out this letter, keeping copies of it. And if you're getting serial medical bills, that can be hard to do. Nonetheless, it's a good arrow to keep in your quiver for limiting exposure on certain treatments and billing codes. Now, what is the whole premise of this system is that most most care in Pennsylvania is covered by the Medicare system. The cost containment regulations in the Workers' Compensation Act include a fee schedule for most medical procedures, which is based on the Medicare rules and the Medicare fee schedule. So for most treatment, there is a set rate essentially. And that's why downcoding is helpful, because you can go from one fee code to another. But we run into the issue, and this is quite common. What if you get a bill for a procedure from a medical provider who's licensed in Pennsylvania, and the procedural code is not covered by Medicare, and it's not on the Pennsylvania fee schedule? What do you do then? Because, how do you process that bill? Do you just deny it? Well, the Act actually provides that in those instances, defendants are actually required to pay those bills, and they're required to pay them at 80% of the usual and customary charge. Now, that is a hugely, huge lift in terms of a fact-intensive inquiry, right? How do we determine what is the usual and customary charge for a particular procedure in a particular geographic region from a particular provider? Well, the Bureau, in all its wisdom, has actually outsourced that issue. They rely upon a database published by Fair Health, which includes the rates for the usual and customary charges for various procedures. And your medical billing unit or your medical billing vendor should have access to that database to help on cost savings. Another issue is what happens if the specific procedural code is not covered by Medicare and for whatever reason is not in this database. At that point, you probably want to consider investigating further and perhaps contacting our office, because we can help you to determine whether cost savings would be sufficient to engage litigation efforts. We've had successful efforts in the past litigating what constitutes the usual and customary charge for specific procedures. Just offhand, we had one case where a provider was seeking over $20,000 for a platelet-rich plasma injection, and we were ultimately successful in proving that the usual and customary charge for that procedure was under $1,000.
So Barack, I want to get to questions, but before we do, can you touch on average wholesale price, why that matters in the fee review context, and then just give a sentence or two on the issue of prohibited self-referrals?
Yeah, absolutely. So the Medicare fee schedule we talked about is for procedures. For pharmaceuticals, they use an older model. The Act says that pharmaceuticals are to be reimbursed limited to 110% of the average wholesale price of the drug. It doesn't really provide any more information on those specific terms. The regulations following the Act, published by the Bureau, say that the Bureau can choose amongst industry indexes, that nationally recognized schedules that publish this data. And subsequently, the Bureau always chooses this one particular industry publication known as the Red Book. And the Red Book supposedly lists the average wholesale price of any drug under the sun. The problem you run into is that if you research the issue at all, you'll find that there's been a lot of litigation about this in the past, not just limited to Pennsylvania, not just limited to workers' compensation. Medicare does not use Red Book anymore. It does not use this concept of average wholesale price. The term, the AWP, average wholesale price, has also been referred to as ain't what's paid, because a lot of these fees are grossly inflated. And we'd be happy to discuss that issue some more, perhaps at a future seminar dedicated to fee review and these issues in particular. The other issue I wanted to touch on was prohibited self-referrals. The Act actually includes explicit language saying that providers are not allowed to refer patients to entities or individuals with whom they have a financial interest. And the Act actually sets out specific categories for those self-referrals. They include laboratory, physical therapy, rehabilitation, chiropractic, radiation oncology, psychometric, home infusion therapy or diagnostic imaging goods or services. This is something that you want to be aware of. It is something that is litigated in the fee review context. If you have reason to believe that a provider has financial interest in the entity or individual where referrals are being sent, please contact us and we can advise you as to next steps.
Yeah, thank you, Brock. I think that we will be doing a follow-up seminar specific on fee review because it's a case where it's an area of Pennsylvania workers' comp where a lot of money is spent, and I'm not sure everybody's as familiar with it as they should be or as they want to be. So we always get questions on fee reviews. We'll do a seminar specific to fee reviews. I know that when Barack says, medical cost containment regulations, your ears perk up. So if that's you, and that's exciting, keep your eyes open for the future seminar. John, I assume you don't have a different understanding of the fee review process in Pennsylvania. Did Barack hit on everything from your perspective and experience?
Yeah, Barack laid it out very well. The only point I would add is once you get in front of the fee review hearing officer, please understand that it is your burden as the insurer to prove the case, and that oftentimes it's very important because the provider doesn't have to do anything, spend any money, and they wait for us to prove the case. So that can be, frankly, one of the most important factors on whether or not to take a decision to that level.
Yeah, and I think that's a great point. That's exactly what we were talking about with denying medical bills with intent. If you're going to be repricing or challenging or trying to change anything in fee review, as Barack explained, we don't file fee reviews. We don't file fee review requests, fee review hearing requests. We don't do any of that. That's all done by the providers. The way that we create issues with fee reviews, the way that we are aggressive on the carrier and employer side, is we make payment. There's a scene, I don't know if anybody who's watched Mad Men, there's a famous scene where Peggy's really mad at her boss, Don Draper, about how he doesn't appreciate how hard she works and everything she's done for him. And his response is, that's what the money is for. That's what I pay you for. That's why I give you these raises. And essentially with fee review, that's exactly what it is. You make your argument through your payment. So if you're going to pay less for something, have a reason to do it. Because when you get before the fee review officer, as John just said, you're going to have to say why you paid that amount. So I'm not telling you don't pay $1 for the spinal fusion surgery, but if you're going to pay $1 for the spinal fusion surgery, have a reason to do it, because you're not going to win in the long run if you don't. So tune back in for our fee review seminar. We have a bunch of good questions that I wanted to get to as quickly as possible. A couple in the Q&A section, one misguided soul through a question in the chat section, but that's okay. We won't judge. First question that we have is, and I'll read it before I say it so that I don't sound as dumb as I sometimes do. This is about treating with the panel. So if the employee wants to treat with a specialist that an employer does not have on their panel, am I correct that that still falls under payment by workers' compensation? Guys, so the situation is the employee has a concussion. They want to treat with a neurologist. There's no neurologist on the panel. The employee can go to any neurologist they want to or who they're referred to, and the carrier is going to be on the hook, correct?
Yeah, correct. You're not going to be able to avoid payment in that situation. And it's a good question because it does hammer home the point that even if you have a panel, this is not a way to necessarily avoid payment for the treatment on the panel. You're going to be liable for that medical treatment. And yes, simply put, if there is a specialty and it does arise that is not necessarily on the panel, you will have to be liable for that treatment. Again, hammering home the point, please take some time to review the panel if you're an employer or an adjuster and make sure you have that covered. This is where coordinated care organizations may have, they have a neurologist on board, they have an orthopedist. Those are primarily the two big ones you see. But we do see injuries beyond that in workers' comp. So short answer, yes.
So there was another question that's not specific to payment of medical treatment, although it could be. Any claim that's accepted in Pennsylvania has a medical aspect to it. It's a COVID question. And the question is essentially, and this question asker is so lucky because John Spadea is here today, and I know he's the foremost expert in presumptions for COVID because I did a seminar with him about it a year or two ago. The question is, did Governor Wolf ever provide an executive order for paying COVID claims for all essential workers early on in the pandemic, or all add since? And I believe that answer is no, and I don't think that's changed. Is that right, John? Is there any presumption for essential workers?
No, Pennsylvania is not a presumption state. And for those that don't know, basically, once COVID hit, about half of the states in the country adopted a presumption law. And it's basically a law that said if you get COVID, it is presumed to be at work and a work-related injury. Without delving too deep into it, it was a mechanism so that people could get treatment and get that treatment covered if they got COVID. Pennsylvania does not have a presumption law on the books. I think it's a reason why we haven't seen a mad dash rush of COVID cases. They do exist. I'm litigating a couple right now, but it is a much more difficult burden to prove because now instead of the defendant, like in fear review, having to basically overcome that presumption with evidence, it's on the claimant. And COVID is, as we all know, everywhere and easily contracted from almost any interaction. So it's a hard burden to prove. I will caution that certain cities and smaller municipalities have adopted their own ordinances. I know because of a case I'm litigating, for example, the city of Philadelphia has adopted not a presumption law, but has established special benefits that must be applied if a worker gets COVID. And they're very specific, but these do come up if you're litigating one of these cases. Again, reach out to us. We're happy to discuss it in further detail. Again, short answer, no, Pennsylvania is not a presumption state.
Excellent. The next question is for Barack. It says, Barack, I thought your presentation was excellent. And if you ever write a book, I would like to read it. They didn't actually say that. I'm just buttering you up because I'm going to stick you with the tough question. The question is, and I think this is a good question. It's longer. I'm going to try to summarize it. And as often the case, I probably screw it up as I summarize it. But they're basically asking if you have a right as the carrier, employer, TPA, to request treatment records from a prescribing physician when all you're receiving are the prescription bills. So you're getting prescription bills for ongoing opioids that the claimant's been using for 2 years. Do you have a right to have the treatment records from the physician who prescribes them before you have to pay the bill?
Yeah, I mean, if you have no reason to believe that the treatment is causally related to the work injury, you can request those reports. And the Act actually provides a mechanism for defendants to request that information. Furthermore, if a bill is denied for lack of supporting documentation, the providers can simply resubmit it with the required documentation. So the denial is not necessarily final. If you need those documents to make a determination of whether a prescription is work-related, ask for those documents.
Okay. So as a reward for those attendees who stuck around, we have one question left over that came from the chat section. And again, I'll chastise the question asker, but it's a good question, so I'll still do it. But in the future, anonymous question asker, you get yourself to the Q&A section. The question here is, and it's nothing we talked about to prepare for this, so this is always fun. There was a decision that came down, I don't know if it was Pennsylvania Supreme Court, it might have been within the last several weeks, in which the court found that a workers' compensation judge can award attorney fees to a claimant's attorney, even if that judge finds that a reasonable contest occurred. And for those who might be unfamiliar or have forgotten, in Pennsylvania litigation, traditionally, if you're litigating a series of petitions, it's the responsibility of the defendant to prove that they presented a reasonable contest to the positions and in support of the petitions. So if you file a claim petition as the claimant and I present no medical evidence whatsoever, there's a chance I haven't presented a reasonable contest. If that's the case, the claimant's attorney can ask for reasonable contest fees, quantum merit. They tell the judge how many hours they put into the case, and the judge can award payment of those attorney fees to the claimant's attorney, to the claimant. So the decision that just came out recently said that in limited circumstances, I would argue, and in that case, I believe it was a medical only scenario where the claimant was not receiving wage loss benefits, therefore the claimant's attorney was not being paid. In those situations, such as was before the court in that case, the judge can award attorney fees. Even if the defendant reasonably contested the case, the judge can give attorney fees to the claimant's attorney. All my claimant attorney friends got super excited. I think for the most part, they agreed with me that this is going to be situations where the attorney doesn't have some other access to fees. I don't anticipate a lot of judges awarding quantum merit in a case where the attorney's already getting 20% from an ongoing wage loss, but it's something to be aware of. So number one, you guys hopefully are aware of that decision?
Yeah.
Yes, I see.
Yeah.
I see nodding heads. So the question that we're being asked is, as a result of that decision, do we anticipate there's going to be more litigation, more petitions about medical treatment than we've seen previously? And what the question asker, I assume, is getting at is there's now potentially financial motivation, or even just if we're being fair, the well-intended superhero claimant's lawyer can now get paid for doing good deeds. And in this case, the good deed is getting the claimant's medical bills paid, even if it's a medical only claim. Do you guys think that's going to lead to more litigation about medical exposure that we've talked about today?
I certainly think it can. I'm with you that I think the case is limited and narrow, but I do see situations that you're intimating, hinting at. I'm sure we all have cases, older cases, where maybe indemnity was settled years and years ago. There's no fee being collected, and either the claimant doesn't have an attorney or their attorney hasn't done anything on the case in years, and there's really no impetus financially for them to get into a big litigation or a big fight. I think now there is. So yeah, I guess short answer, we will see more cases where we may not have otherwise. I don't think we're going to see the floodgates open, so to speak, but that's just my opinion.
Brock, do you agree?
Yeah, I think I don't know if the floodgates are going to open, but I think this makes, from a business of law perspective, for claimants' attorneys, this makes litigation on medical only claims much more palatable. So on those claims, you probably will see some increase, and we're happy to litigate those as well if we need to.
Yeah, I think just to tie it into our discussion today, fee reviews, unless you really screw up, you're not going to get counsel fees awarded in a fee review litigation. So it's not going to be an issue with fee reviews. One thing we didn't touch on that is important, and I'm just thinking out loud, the right of appeal for a fee review is directly to the Commonwealth Court. You don't mess around and waste time. Looking at hopefully there's no judges or board members on the panel here, as I say the quiet part out loud, but you don't waste time before the appeal board waiting for them to do their due diligence and issue good decisions. You go straight to the Commonwealth Court. So it's a little more, there's a little more brevity there, and you can get more done from a legal decision and a precedential standpoint in fee review. I don't think you can get attorney fees awarded in the fee review. You would really have to mess up. But with regard to the utilization review, and Brock talked about get your IME report potentially before you file a utilization review request. If you're in a situation where you did not do that, you filed a UR request, you said that massage therapy is BS, I'm not going to pay for it, I want it to be UR'd, and the UR comes back and said that massage therapy is just great, and it's reasonable, necessary, and causally related, and you should pay for it forever. If you challenge that then, and we've done this, we do this sometimes, you might challenge a UR determination because you got an IME 5 weeks after the UR determination that said the claimant's fully recovered, or whatever the case may be. I think in those scenarios, if it's a medical only claim, then the fees might come into it, because you didn't even have a basis to request the UR. The UR was not in your favor, and then you filed a petition to challenge it. I think I would be wary of that. Where I would really be wary, and guys, you can tell me what you think. We all have those old dead dog 10, 15-year-old claims that are now in medical only. And lo and behold, Dr. Nick finds the claimant fully recovered despite their spine cord stimulator and their 3-level fusion. Claimant's fully recovered. Congratulations. And a typical tactic, it would be to file a termination petition. And we'll get it before a judge, and we'll get the claimant to court, we'll mediate, and hopefully we can settle out this medical exposure and everybody has a good day. If you don't have a good day, you didn't listen to our seminar in 2 months from now about how to properly settle your cases, the claimant's completely unreasonable, and you can't get that case settled, and you go to a decision with your full recovery on the spine cord stimulator fusion from 15 years ago, you have a reasonable basis. Your reasonable basis for the litigation was the IME. But what do you guys think about a judge awarding attorney fees in that situation?
Yeah, I think that's a good fact pattern to consider, because I as a business of law, issue again, I don't necessarily think the judges like sending attorneys who are doing claimants attorneys who are putting in hours in good faith home empty-handed. And if the if the courts are giving them a basis to award fees in those instances, I think they will.
Yeah, and I think it's just to hammer your point, Jason. I think it's important just to go in that scenario, and I've done it myself. I've seen it done a lot. Just go in with open eyes, know what you're doing. If you're really just trying to get the case settled, keep that in mind. It used to be you have that IME that is, I would argue, per se reasonable basis, but now with this new case, that may not be so. So just again, go in eyes open. That could be a potential outcome. Typically, hopefully, your attorney, especially if it's a Chartwell attorney, will know the other attorney on one of those cases and can try and reach out and feel them out and say, hey, can we get rid of this case before we need to go to litigation, and avoid that whole issue altogether.
Yeah. All right. Well, I think that's all the questions, and we've definitely gone over on time. So I thank all of you that hung around for the whole presentation. The three of us will probably be back on fee reviews. It looks like that might be May or June. So, do what you can to pass the time between now and May when you're going to spend an hour learning about Pennsylvania fee reviews. But for the time being, thank you both. This was fun for me. Hopefully it was entertaining and educational to somebody out there. And we thank everybody for participating today.